Thanks. So what I'd like to focus on, following on Shantanu's talk, is a little bit about providing the U.S. perspective, taking you through the very boring patent dance, and looking a little bit at one of the pending cases that may, in fact, end up in the Supreme Court. We don't know yet. So this morning, the focus of the plenary session was on the interface between competition law and IP. In fact, when we're talking about biosimilars, we're really talking about the interface between regulation of biosimilars and IP. And in the United States, the regulation that's in place has as its stated purpose, whether it meets that purpose or not, we really don't know, but has as its stated purpose to be able to resolve issues of potential patent infringement in an orderly, efficient, and early way in order to pave the way or not for the approval of biosimilar drugs. So in the U.S., as Shantanu mentioned, to be approved as a biosimilar, a biosimilar has to be highly similar to an original FDA-approved biological product, to, in fact, the reference product that Shantanu mentioned. And to get FDA approval as a biosimilar, there really very basically can't be any clinically meaningful differences in safety or effectiveness from the reference product, but there will, in essence, be minor differences and can be minor differences in clinically active components that are permitted. And the basic difference, I guess, between a biologic and a small molecule drug that we're thinking of is basically, and again, this is very high level, that a product manufactured in a living system, such as a microorganism or a plant or animal cells, is basically a biological drug, and a small molecule drug is manufactured through chemical processes. The difference also is that a generic drug is basically the chemical equivalent of its parent, whereas a biosimilar will likely and pretty much almost always have slight variations in its structure from its parent. It is generally more structurally complex, it's bigger, it's heavier, it's less stable, it often can't be characterized in the laboratory, and there really is no way to guarantee that each drug of the dose will be identical, and it will generally require more approval, more testing before it can be approved. And it's for those clinical reasons that generally, as Richa pointed out as well, that there is recognized the need for special legislation, special regulations concerning biologics and biosimilars. In the U.S., the legislation is the Biologics Price Competition and Innovation Act, which is a very horrible name, so it's just really referred to as the BPCI Act. What is less known about the act was that it was actually adopted as part of Obamacare, which I'm sure you know is currently under threat. It was Title VII of the Affordable Care Act. It's been codified under the Public Health Service Act, and if you wanted to look it up, it's in Title 42 of the U.S. Code, and it's basically a lot in Section 262. Just like the Hatch-Waxman Act creates a pathway for the approval of generic drugs, the objective of the BPCI is to create an abbreviated pathway for the approval of biological products, and particularly for biosimilars that are in fact highly similar, or as pointed out by Shantanu, or interchangeable with an FDA-approved biological product. As I mentioned, the goal of all of this is to allow the producers of biosimilars to rely on what's already known about the reference product in order to avoid unnecessary and duplicative testing with the overall goal of decreasing the cost of biological products. As I mentioned, to be a biosimilar, you've got to be highly similar. There shouldn't be any clinically meaningful differences. The other factor, or another factor about the BPCI, which Shantanu mentioned, is the notion of market exclusivity and data exclusivity. And these are important because they lead to the patent dance that I want to dance your way through, at the risk of putting you all to sleep, but I'm going to take that risk. The market exclusivity for a biological product is 12 years. So even if there is approval for a biosimilar, the biosimilar can't take effect until the biological product has been in the market for 12 years, and you can't submit an application for a biosimilar product for 4 years after the biological product has been licensed. That's the data exclusivity. What is the patent dance? The purpose of the patent dance is to try to resolve patent disputes between the producers of the biosimilar and the reference product sponsor, the producers of the reference product, in an orderly and early way. Probably the most important element of the patent dance is the initial stage, the first step of the dance. Under the Act, within 20 days of the acceptance by the FDA, the Food and Drug Administration in the US, of a biosimilar application, the biosimilar applicant is supposed to provide a copy of the application to the reference product sponsor, to the owner of the biological product, and also provide information about the manufacturing process. The purpose of this is for the reference product sponsor to determine whether the biosimilar would infringe any patents that are owned or exclusively licensed by that. After that first step, a whole series of steps follows. Some of these make sense, some of them don't, but they're all part of the dance. So within the next 60 days, the reference product sponsor has to identify the patents that it owns or that it exclusively licensed and that it thinks would be infringed if the biosimilar product were made or used or sold in the US without a license from the product sponsor. If the reference product sponsor is willing to license any of its patents, it also has to identify those. This part is really important because if the reference product sponsor doesn't list those patents, the reference product sponsor loses a remedy for infringement for those products. So then you move to the next step. Within the next 60 days, the biosimilar applicant has to tell the reference sponsor product whether it is going to be marketing the biosimilar before the products have expired, and if it is going to market it before the products have expired, why the products are either invalid, unenforceable, or not being infringed. It could also provide the reference product sponsor with its own list of patents that it wants to pull into potential litigation and affirmatively telling the reference product sponsor that these are either invalid or unenforceable patents. Then we move to, again, the next step. The reference product sponsor has to provide a detailed statement why it believes that the patents that it wishes to enforce are in fact valid and infringed. You now begin a short period of basically about 2 weeks of negotiation. And the parties are supposed to negotiate the patents that they wish to actually litigate. And if that negotiation is successful, then the reference sponsor product has to initiate litigation infringement actions concerning those patents within the following 30 days. And the reason, of course, why the reference product sponsor can do that is, as Shantanu pointed out, the act of filing an application for a biosimilar is considered an act of infringement in itself. If the parties can't reach negotiation, then the biosimilar applicant has to identify the number of reference product sponsors' patents that it wishes to litigate. And this is the part that, frankly, I don't get and I don't understand. So if any of you do, it would really be helpful to me to explain why this is the case. But the reference product sponsor, the biosimilar product applicant names a number. The reference product sponsor identifies the patents that it thinks should be litigated, and the parties exchange their lists. And the number of patents identified by the reference product sponsor can't exceed the number of patents provided by the biosimilar applicant. So they basically, again, set the stage for litigation, and again, the reference product sponsor has to bring patent infringement litigation over those patents within the following 30 days. And if the reference product sponsor fails to bring timely suit, then the only relief that will be available to the reference product sponsor is a reasonable royalty, as opposed to infringement damages. Now, the purpose of this is supposed to be to help ensure that the patents that are alleged to be infringed will be litigated early in the application process. In addition, there is a commercial marketing notice requirement. The biosimilar applicant has to provide the reference product sponsor with notice at least 180 days before the biosimilar applicant intends to commercially market the biosimilar. And in fact, this notice triggers a whole second phase of litigation and frees the reference product sponsor to sue on any of the patent claims that the reference product sponsor has not yet asserted. And the reference product sponsor is also permitted to seek a preliminary injunction if the patent litigation is still in process, to block the commercial litigation of the commercial marketing of the biosimilar until that patent litigation has ended. That's the system, as complex and perhaps crazy as it is. It is now being challenged. And this is a case that I'm sure many of you are familiar with. It's the case of Amgen versus Sandoz. In a decision, actually, that Shantanu mentioned, decided by the U.S. Court of Appeals for the Federal Circuit in 2015, on petition now to be heard by the Supreme Court. Actually, the Supreme Court was supposed to have decided on June 6th whether or not it was going to grant leave to appeal. But it didn't. And I checked last night the U.S. Supreme Court blog, the calendar, and according to that calendar, now they are supposed to meet tomorrow. The Supreme Court meets in conference to decide which cases it wishes to hear, and it's supposed to have that conference about the Amgen versus Sandoz case now, actually tomorrow. So we may have a decision before we all go home. So what's this dispute about? In May of 2014, Sandoz, who's the biosimilar applicant, filed an application for approval of its biosimilar version of Amgen's biologic Neupogen. Sandoz's biosimilar is called Zarxio. On the 7th of July, the FDA notified Sandoz that it had accepted the application for review. instead of commencing the patent dance, what Sandoz did, in fact, the very next day, was to notify Amgen that it intended to market Zarxio as soon as the FDA approved its application, and it was not going to participate in the dance at all. It did not provide Amgen with a copy of its application. Amgen immediately responded by saying, but the patent dance is mandatory, and that notice, that the commercial marketing notice can't be given until the biosimilar product is approved. So the battle lines basically were drawn immediately. On the 6th of March, 2015, the FDA announced the approval of Sandoz's biosimilar application, which I believe was the first biosimilar application approved by the FDA. And so Sandoz immediately notified Amgen that it was going to market Zarxio immediately. And again, Amgen alleged that that Sandoz could not give its notice of commercial marketing until, in fact, the 6th of March. And the 180-day waiting period had to begin only then. This scenario went to the Court of Appeals for the Federal Circuit. The Court of Appeals generally meets in 3-judge panels, and it was a divided panel that ruled that, in fact, the information exchange and the patent dance was not mandatory. It's purely optional, and that a biosimilar applicant could choose or not to choose to follow it. And when the biosimilar applicant chooses not to follow it, then the remedy is that the reference product sponsor should bring an action for infringement against the biosimilar applicant. And so the Federal Circuit argued that Sandoz's decision to opt out was not a violation of the Act. However, the court also ruled that a biosimilar applicant can only give effective notice of marketing after the FDA has licensed the product. So as a result, Sandoz's immediate notice of commercial marketing couldn't be effective, and the 180-day waiting period could only begin on the 6th of March, which was the day when notice was given. It ruled that the notice provision under the Act is actually a standalone requirement and must be abided by whether or not the applicant takes advantage of the patent dance. It also ruled that the 180-day period is enforceable by an injunction if the applicant doesn't comply. So in essence, Amgen could have gotten an injunction against Sandoz. Both parties requested a rehearing of the entire bench of the Federal Circuit, but the Federal Circuit refused the request, and so both parties actually sought review by the Supreme Court. And if the Supreme Court grants this review, it will be the first of the Act. Okay, just a little bit more? Okay, so super quickly, Sandoz's petition says that the commercial marketing focuses on the commercial marketing requirement because that's where they lost, and Amgen's petition to the court focuses on the mandatory nature or not of the patent dance, and so in a fairly unusual measure, the cases are actually cross-references. So if you look at either Sandoz v. Amgen or Amgen v. Sandoz, those are both cases pending before the Supreme Court. What often happens in cases of statutory interpretation is that the Supreme Court asks the Solicitor General, which is basically the executive branch's lawyer, to intervene and to give the Solicitor General's view as to whether the Supreme Court should grant cert. And that's what they did in this case. And the Solicitor General recommended that the court grant certiorari, grant leave to appeal. It also reviewed the questions presented in both petitions, and it actually said, court, not only should you grant review, but this is how we think you should decide the case. And what the court said was that they should side fully, that what the Solicitor General said was that the court should side fully with Sandoz. That giving notice of commercial marketing before the FDA approval, according to the Solicitor General, and contrary to what the Federal Circuit said, is completely consistent with the Act. That, again, inconsistent with the Federal Circuit, that injunctive relief should not be available for failure to furnish notice of commercial marketing, because nothing in the Act creates a remedy of seeking an injunction. And then finally, again, siding with Sandoz, but also in this case agreeing with the Federal Circuit, that providing the information and starting the patent dance should, in fact, be completely optional, and the reference product sponsor's remedy is to bring an action for infringement. So the basis for the Solicitor General's statement is really based very much on policy. And as was pointed out by all of the panelists, right now, because of the growing importance of biosimilars, because in the US, and based on 2013 statistics, there were approximately $80 billion spent on biologics in the US, and about 25% of all drugs in the US are biological products, biological drugs, that there really needed to be an answer to this question so that we know how we should go forward in terms of interpreting the Act. In general, it's viewed that if the Solicitor General says, court, please accept this case, that the court will accept the case. However, as we know from the election in the US and everything else recently, that what we normally think and can predict doesn't often turn out to be the case. Shantanu and I were having a discussion beforehand, and we both kind of came down on the court not granting cert. So we'll find out tomorrow whether we are right or not. But in any event, this is going to be important because either the law will remain as the Federal Circuit has said it, or it will perhaps change. And whatever it is, the result should probably come either tomorrow or by the end of June of 2017. Thank you.